Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
My name is Alexandra Tratnik, and I'm here today to talk to you about employee versus independent contractors and the implications to employers. I'm also a lawyer with Devry, Smith & Frank. My primary practice is commercial litigation, debt recovery, and of course, employment law. There is a growing trend these days in hiring workers as independent contractors rather than as employees to perform services. This trend is primarily a result of a number of factors, including greater flexibility, reduced overall costs, and often a greater specialization that contractors may be able to bring to the employer. The distinction between independent contractor and employee relationships is difficult to determine, and the line is becoming more and more blurred. This distinction, however, has important implications for a company's practices for a number of reasons. As an employee has certain rights on termination that are generally not available to contractors. Additionally, an employer is under statutory obligations regarding withholding and remissions for income tax, EI, and CPP contributions. Further, employees have certain entitlements under the ASA, such as overtime pay, minimum wage, pregnancy and parental leave, and paid vacations, which are not available to contractors. As such, it is critically important to distinguish between working relationships based on an employment contract in which the worker is an employee and where they are considered to be an independent contractor. Problems arise when you treat the worker as an independent contractor, but the nature of the relationship has some characteristics that suggest or resemble a more traditional employer-employee relationship. These kind of relationships typically fall along a spectrum with, the independent contractor on one end and the employee on the other, and the courts have a number of tests to determine where the person will lie on the spectrum. Recently, actually, there has been an emergence of a third category called a dependent contractor, which I will discuss a little bit later. So at its most basic level, the employer-employee relationship exists where there is a contract of service between the parties. In contrast, an independent contractor occurs where there is a contract for service. For such contractors, the laws governing the relationship consist of the law of contract rather than the employment statutes, such as the ESA. The starting point for making the determination of whether or not a worker is an employee is a classic four-fold test, which looks at whether the individual is in business for himself or herself by examining four factors. The first one is control, or the level of control that the worker has. Whether the employee, for example, gets to choose his own hours, whether he has to come into a specific place of employment, or whether he can work from home. The next topic, or the next point here, is ownership of tools or equipment or resources. Does the company provide these, provide your computer, provide your tools, or does the worker have his own tools that he uses for the job? The third point is a chance of profit, whether the individual has a chance of making a profit with the work he does, or whether it is an hourly or salary-based remuneration. The fourth point here is a risk of financial loss, whether the worker's output is, if something bad happens, is he going to suffer financial detriment, or whether the company will take on that loss. The leading case in this area is Number Company versus Segas Industries Canada Inc., in which the Supreme Court stated that the central question of whether the person who has been engaged to perform the service is performing them as a person in business on his own account. In making this determination, the level of control the employer has over the worker's activities will always be a factor. However, other factors to consider include whether the worker provides his or her own equipment, whether the worker hires his or her own helpers, the degree of financial risk taken by the worker, the degree of responsibility for investment and management held by the worker, and the worker's opportunity for profit in the performance of his or her task. It bears repeating that the above factors constitute a non-exhaustive list and that there is no set formula as to their application. There are a number of other particular and contextual factors that are considered in making your determination. I'll go through a few of them just as an example. Where a worker is more likely to be considered an employee is when the company selects who will perform the services. Whereas an independent contractor, they get to choose who will perform the services. Another example is the company directs the day. The worker has the company directs day-to-day work of the worker. The company controls the method and location of performing the work, and the worker is subject to manager supervisory oversight, whereas the independent contractor usually doesn't really have a boss. Someone who's more likely to be considered an employee is usually covered by an employment group benefit plan, health insurance, dental insurance, whereas independent contractor usually would not have this. An employee would not usually have their own GST or HST number, whereas an independent contractor would. Another one, employee typically is trained by the company, where an independent contractor will receive outside training or doesn't receive training from the company. Another one is where the employee works full-time for this company and doesn't work for anybody else, whereas independent contractor will have several clients and can work for competitors, whereas an employee usually, again, works for one company and is not allowed to work for the competitor of that company. Another example is that the worker has previously worked as an employee for the company in the same capacity, whereas the contractor has never been an employee of the company. Again, these are all factors, and none of them are determinative in and of itself. A couple of things to note. Although the intentions of the parties, the common intentions of the parties might be a factor in determining whether the worker is an employee or an independent contractor, it is important to note that a contract outlining the relationship between the parties is not determinative. That means that if you have a contract that says this worker is an independent contractor, the courts might not agree with you and might consider him an employee. So it's just one of the factors that the courts will look at when determining the status of the employee. Further, the status of the employee is not fixed. All statutes have particular policy goals, so it's possible that a worker might be considered an employee under one statute, but not considered an employee under another statute. For example, the employee could be considered an employee under the ESA, or the Employment Standards Act, but it might not be an employee under the Canada Labour Code, and it might not be an employee under the Income Tax Act. So you really have to look at which act is applicable to you. The Supreme Court of Canada has made it clear that courts and tribunals must take into account the particular policy objectives of the particular statute when deciding if a person has employee status. So legislation which has as its purpose the protection of employees is interpreted broadly in order to ensure maximum coverage consistent with that purpose. So therefore, workers are more likely to be found employees under the ESA, the Workers' Compensation Act, more so than under the Income Tax Act, for example. So the implications of classifying a worker as an independent contractor, perhaps when they should have been classified as an employee. If a worker is incorrectly labeled as such, the employer would have likely have failed to withhold and remit CRA income tax, CPP contributions, and EI premiums from the money that was paid to the worker. Employer and employee portions of the CPP and EI will have to be paid back to the government. The CRA could also assess the employer for penalties and interest as a result of failing to remit these things. Another thing is the employer would likely have failed to report in a T4 the worker's income from employment for each taxation year at issue, which could also attract a penalty from the CRA. Improper classification can also be costly for the employer as a result of legal fees for defending a challenge by the CRA in the tax court.